This is the story of the United States of America versus Charlie Kim and Megan Messenger.
The core of the case was the government's allegation that Charlie Kim and Megan Messenger had bribed a 4-star U.S. Navy admiral. And the allegation was that they had offered to hire the admiral after he retired from the Navy at their company NextJump if the admiral gave them a contract for NextJump while he was still in the Navy.
This was a tough case from the get-go because there really was no dispute about the core facts, which were that our client had offered a job to this admiral at the same time that he was talking to this admiral about a contract.
But we sort of flipped that narrative on its head. And we used the fact that Charlie had openly and in good faith disclosed all of this evidence to anyone around him as the core evidence of good faith in the case that he didn't act corruptly as the federal bribery statute requires.
And actually, one of the first conversations that we had with Charlie, he told us something very important, right? Which was that the admiral, who was the number 2 person in the Navy, he was extremely high up. And he'd been the chief ethics officer for the Navy, the chief ethics officer, that this admiral had told him, you can do this. We can have a conversation at the same time about a job, at the same time we're having a conversation about a contract. And I thought that was fine because of who I was talking to. And very importantly, the one thing that Charlie always said he never did, and that we don't believe the evidence ever supported, was that he wasn't saying, I'll give you a job in exchange for a contract, or the admiral was saying, I'll give you a contract in exchange for a job.
That's exactly right. From Charlie's perspective, of course he wanted a contract for his company. And he also independently wanted to hire this war hero, right? This military leader, because that also would have been good for his company.
We realized very early on that our defense was that the admiral had told Charlie that you could do this. And if we were doing that in the same trial with Admiral Burck, we would basically be another prosecutor against the admiral.
Right.
So we moved to sever the trials, which is rarely granted. We made the argument well, and Judge McFadden, who's an excellent judge, granted the motion. And so that was the critical initial thing that happened in this case, was that we got ourselves separated from the admiral so that he wouldn't be pointing fingers at us in the same trial, and we wouldn't be pointing fingers at him.
We tried the case once in front of a jury in D.C. last August. And 2-week trial. The jury deliberated for 6 or 7 days, and they deadlocked. They insisted on taking it to trial again.
They tried to make it a stronger case for them than they had the first time.
And they came back with a not guilty verdict on conspiracy, on bribery, and even on a lesser charge that the government had tacked on this time of illegal gratuities.
Right, full acquittal. It is very rare that you see in a white-collar case that the government doesn't have proof that a person lied about something, misled about something, kind of like was shady about something. Our client, we could say with a straight face and with hand on heart, never lied about anything to anyone throughout this entire story, and that the government was not able to counter that.
He came to Quinn because he wanted to fight, and because that's what we do. There's no law firm of our size that tries as many federal criminal trials as we do. We've got the experience to back it up, and he knew that. He wanted a firm that could fight aggressively for him rather than just plead him out and try to get a good deal.